Hello, my name is Ruby Sanchez, and I'll be talking about partnerships. I'll be talking about what a partnership is and when does it exist, what a partnership agreement entails, and the rights of the partners, the duties of the partners, the effect of dissolution, and distribution upon termination. So what is a partnership? A partnership is a single business where two or more parties with the same interest to conduct business activities associate in an agreement to place their money, property, and/or labor in a business and to divide profits and losses. So the parties involved must have consented to the formation of the partnership and must have agreed to participate in the profits derived from the partnership business to contribute property, skill, or industry to the partnership in agreed upon proportion. Also, all parties must share in business profits as well as losses, allocated per the agreement. As well, the property or stock of the enterprise must form a community of goods in which each party has a proprietary interest. Because partnerships entail more than one person in the decision-making process, it's important to discuss a wide variety of issues up front and develop a legal partnership agreement. This agreement should document how future business decisions will be made, including how partners will divide profits, resolve disputes, change ownerships, and how to dissolve a partnership. Although partnership agreements are not legally required, they are strongly recommended and is considered extremely risky to operate without one because oral and or written statements by the parties carry a substantial weight of proving that a partnership really exists. The most important document of a partnership is the partnership agreement, which is in it the terms and conditions agreed upon the partners. The content of the partnership agreement varies, however, it usually contains the partners' names and the partnership name, its purpose and duration, the capital contributed by each partner, the method of distributing profits and losses, the effect of advance, the salaries to be paid to the parties, the method of accounting, and the fiscal year, the rights and liabilities of the partners upon death or withdrawal of the partners, and the procedures to be followed upon dissolution. A partnership agreement can be very helpful in a business dispute and to make sure that they did not arise in the first place. When partners agree upon a name, they should know not to use a company or other language that would imply the existence of a corporation, because a name is an asset and may be sold, assigned, or disposed of in any manner on which the parties agree. Common law allows partnerships to sue or be sued in the first name. Also, partnership capital consists of total credits to the capital accounts of various partners, provided the credits are for permanent investments in the business. The amount each partner is to contribute to the firm, as well as the credit they receive for assets what they contribute is entirely dependent on the partnership agreement. As well, with property, the partners may choose to use their own property or an individual partner's property or the property of a third party. The agreement will entail which property is classified as partnership property. Unless a contrary intention appears, property acquired with the partnership funds is partnership property. So there is a presumption that property acquired with partnership funds is partnership property. However, this belief is rebutable. If a partner individually obtains property, it is often transferred to partnership as part of capital contribution. He then has not greater entity on the property than another in the party. So at dissolution, he would only recover the amount that pertains to him. If the partner had purchased property on credit, the lender would not claim against the partnership, even though the property would be traced to the property because a personal loan made to the partner would not become partnership debt unless the partnership expressly assumed it. Also stated in the agreement is how the partners will share the profits and duty each partner has to contribute to the losses. Many times this is equal parts, unless stated in the agreement. Also, capital contributed to the firm is liability owned by the firm to the contributing partners. If, at dissolution, there is not enough capital to repay each partner, the amount is considered a loss, and it must be met like any other loss of the partnership. Continuing on with the rights of the partnerships, all partners have equal rights in management and conduct of business. They may agree to place management within the control of one or more parties. The right to participate in management as partners does not mean the partners owe each other the duty to agree with each other. If partners cannot come up with an agreement, then the partnership agreement should provide for some form of arbitration between the parties to avoid dissolution. In this case, the majority could not decide on changing the nature of business or alter the partnership agreement. No partner is entitled to the payment for services rendered in the conduct of partnership business unless they have gave their time, skill, and energy to the pursuit of partnership affairs per the agreement. Also, every partner has a right to fully be informed concerning conduct of the business and to inspect the books to assure that information. As well, each partner has implied authority to receive notices and information from other partners concerning matters of the business. In any case, a suit for an accounting may be used when the partner's proportionate share of partnership assets or profits cannot be determined by a voluntary settlement. A partner has a right for formal accounting when one of the partners feels they are not being accounted for their rights of the partnership. With partnership property, a partner has an equal right among partners to possess partnership property for partnership purposes. However, it has no right to use the property in satisfaction of personal debt. If a partner dies, his or her interest passes to the surviving partner, who has a duty to terminate the affairs of the partnership in accordance with the agreement and the law. After termination is complete, the estate of the deceased partner will be paid whatever sum the estate is entitled per agreement. So whatever the sum estate is entitled per agreement based on the value of the partnership interest is a partnership. The surviving partner will need to find a way to pay the deceased partner portion either by selling or buying his portion. For a partnership to exist, the partners should consist of a fiduciary relationship, one of trust, confidence, and faith. As a fiduciary, each partner owes a duty of undivided loyalty to the other. Therefore, any partner must account to the partnership for any benefit and hold as trustee for benefit of the partnership any profits gained by him or her without consent of the other partner. Each partner has the authority to bind the partnership with the contractual liability whenever he or she is apparently carrying on the business of the partnership in the usual way. If this is not the case, then it will not bind the partnership unless the other partner authorizes it. Each partner has implied power to do all acts necessary to carrying out business of the partnership. In addition to the duties, a partner has the power to impose a tort liability on the partnership through the doctrine of respondeat superior. Each partner is liable for the tort of a fellow partner. If a partner has a liability because of a tort of a partner, the firm may have the right to collect its losses from the partner at fault and the right of indemnity against the partner at fault. The partner's financial powers are determined on whether they are trading or non-trading partnerships. In a trading partnership, each partner has an implied power to borrow money and to extend the credit of the firm in the usual course of business. However, non-trading partnership is more limited and does not imply power to borrow money unless its actions are within the scope of the business. So, dissolutions may be caused by violation of partnership agreements, but not always, because the partners may have simply agreed on the terms, as well as termination and winding up can be caused by a death of the partner. Dissolution by acts of partners. Dissolution may be caused by the acts of the partners, by operation of law, or by court decree. The process of winding up for dissolution involves liquidation of the partner's assets, so cash may be available to pay creditors and to make distributions to the partners. If a partner withdraws because of a breach in partnership agreement, then he or she could decide to be wound up and terminated or to allow the business to continue. If a dissolution is caused by any act or occurrence other than death, the general rule of compensation for the partners still applies. This means that partners still contribute to the winding up process and therefore get paid for their contributing services. So upon a dissolution, an accounting is made to determine assets and liabilities. So after creditors are paid, partners distribute the assets as follows. A partner who has made advances to the firm or has acquired liability on behalf of the firm is entitled to reimbursement. Also, a partner is entitled to the return of capital that he or she contributed to the firm. Next, each partner is entitled to the remaining balance, which is distributed as profits in accordance with the partnership agreement. Goodwill is a partnership asset that should be accounted for in the absence of an agreement. Goodwill will often be defined as the advantage which is acquired by an establishment on account of its local position or reputation for skill or affluence, or punctuality, or from other accidental circumstances, or necessities, or even ancient partialities. When the firm is insolvent and the court has to decide, the court of equity is responsible for making the distribution of assets. The assets are distributed in accordance with the marshaling of asset rules. The rule of marshaling assets is a principle of equity for a fair distribution of a debtor's assets among creditors. And this will conclude my presentation on partnerships.